3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. I'm looking at a wire transfer dated December 6, 2018. LSJE LLC, a U.S. Virgin Islands entity controlled by Jeffrey Epstein, wired payment for 55-gallon drums of sulfuric acid to be delivered to Little St. James Island. That's 330 gallons of one of the most corrosive substances commercially available. The stated purpose on the form: RO plant maintenance. The authorization signature line is blank, and here's what makes this document extraordinary. On the same day this wire transfer was executed, the FBI formally opened a child sex trafficking case against Jeffrey Epstein.
December 6, 2018. That date is the absolute nexus. It's the point where two completely separate paper trails, one financial and one federal, converge.
It's stunning when you see it in black and white. On one hand, we have this document, EFTA 01223564, the wire transfer. And on the other, EFTA 00164551, which is the FBI internal email confirming the case opening. The timing isn't just suspicious, it demands a forensic audit.
It does, and we have to treat it that way, not with emotion, but with process. We need to audit these documents as if we were presenting them in court.
Okay, let's do that. Let's start with the money. Document EFTA 01223564. I have it right here. It looks, mundane at first glance. It's a wire transfer form.
Exactly. It's designed to look boring, but the details are what matter. Let's start at the top, the header.
Originating entity, LSJE LLC. And an address is listed. 6100 Red Hook Quarters, Suite B3, St. Thomas, the ISIC 00808002.
All right, let's break that down. LSJE, we've seen that before.
LSJE. It's the acronym for Little St. James Estate. This was his primary vehicle for the island, right? The shell company that handled payroll, procurement, everything.
Correct. It's the corporate veil. In high net worth structures, the principal's name rarely appears on an invoice for, say, pool chemicals, or in this case, acid. The LLC takes the liability, it creates distance.
And the address, Red Hook Quarters. I've looked this up. It's not on the island. It's a commercial plaza on St. Thomas.
Right. It's a mail drop, a registered agent's office. This is standard practice for creating another layer of separation. The paperwork lives at an address anyone can walk into, a suite in a strip mall, but the goods are going somewhere very private.
An administrative air gap.
That's the perfect term for it. Now, let's move down the form, the banking details.
It says the request was made via SunTrust Bank, but the routing instructions clearly show it went through JPMorgan Chase.
And that is a huge piece of this puzzle. By late 2018, most major financial institutions had dropped Epstein. Deutsche Bank was his last major holdout, and even they were getting nervous. But here's JPMorgan Chase, years after they supposedly severed ties, still in the plumbing, still moving his money.
So they were acting as a correspondent bank.
Essentially, yes, they were facilitating the transaction, and we have to remember this isn't some back alley deal. A wire transfer creates a permanent traceable record within the federal banking system. It's an official act.
A record that shows who was paid. The pay is listed as Gemini Seawater Systems, LLC.
A legitimate vendor for water treatment supplies.
And the amount is $4,373.17.
$4,373.17.
$4,373.17. Now look at the internal accounting codes. This is where it gets interesting.
Okay, I see it. General ledger description. It just says RO, 2 letters.
RO, reverse osmosis.
And the GL number is 6017DOG. What does a code like that do inside a company's books?
It sanitizes the transaction for any future audit. Think about it. An accountant is reviewing the year-end books for LSJE. They see a charge for $4,000 coded to 60170G. They look up the code and it says RO plant maintenance. They see the island has an RO plant. It makes sense. They move on.
So it buries the specifics.
It buries the specifics. The code doesn't say 330 gallons of industrial-grade corrosive acid. It says maintenance. It's a form of internal camouflage.
But the line item description on the attached invoice, that tells the real story. It can't be sanitized. I'm reading it directly.
Please do.
It says, by 655 gal drums, sulfuric acid W fuel, and insurance charge for transport.
Let's just pause on that. 655-gallon drums, that's 330 gallons. To put that in perspective, a standard bathtub holds maybe 40 gallons. This is more than 8 bathtubs full of pure sulfuric acid.
And look at the rest of that line. Buy fuel and insurance charge for transport. That's not a detail you see on a normal delivery.
What does it tell you?
It tells me this was a logistical headache.
Yeah.
Sulfuric acid is a Class 8 hazardous material. You don't just put that on the public ferry to St. James.
So this required special handling.
It required a dedicated vessel, probably a small barge. It required a special manifest, hazmat declarations, and a very expensive insurance rider to cover a potential spill in a protected marine area. The fuel surcharge implies this was a special trip. This wasn't just another box being dropped off by the delivery guy. This was a planned hazardous materials operation.
An operation. And the invoice lists other items, too. Materials for conductivity probes, replacement pH, and cable RO plant. Those sound legitimate.
They are completely legitimate, and that's the point. That's what makes the cover story work. You're ordering the acid. To make it look routine, you bundle it with routine parts. The probes and cables are the camouflage. An auditor sees those and thinks, ah yes, standard RO maintenance. The few dollars for probes provide cover for the thousands of dollars of acid. It's a classic technique.
It's the disparity in scale, though. A few small electronic parts versus 6 half-ton drums of chemicals.
Exactly. The accessories are a footnote to the main event. Now, let's go to the most critical part of this document, the bottom.
The authorization line.
What do you see?
I see a blank space. The line for authorized signature is empty.
In all your years looking at corporate documents, how often do you see a wire transfer for over $4,000 go out with no signature?
Never. It's a cardinal sin of accounting. It's a complete failure of internal controls. Any clerk in an accounts payable department would reject this form instantly.
So what does its absence mean here?
It means the rules were broken. It implies an override.
An override from who?
From someone high enough up that their verbal command is enough. Someone who can just say, send the wire, now. The paperwork is an afterthought. It suggests urgency and authority.
Get this done today.
Yes, get this done today. Which brings us to what today was, December 6, 2018.
Let's put this document aside for a moment and pick up the other one, EFT 0001645551, the internal FBI email.
This one has a different feel. It's not a financial document. It's a narrative. It's a retrospective timeline of the investigation written by an agent. The subject line is Epstein-Maxwell Case and Evidence.
Right. It's a case summary, likely prepared for a briefing or for the official file. Look at the very first timeline entry.
December 6, 2018, case opening.
Case opening. That's a bureaucratic term, and it's incredibly powerful. Before that date, Epstein was maybe a subject of inquiry, a file being reviewed, but a case opening changes everything.
What does it trigger procedurally?
It triggers the full force of the Bureau. A formal case number is assigned. Resources are allocated. Agents are put on the case full-time. A budget is created for surveillance, travel, witness interviews. It moves from a possibility to a certainty. The federal government is now officially investigating you.
The email gives the context. It says the Southern District of New York, the SDNY, had contacted the FBI's New York office.
Right. The SDNY prosecutors likely got new information, maybe a new victim came forward, and they decided to move. They engaged the FBI as their investigative arm. This is how these major federal cases begin.
And the timeline shows they moved with incredible speed after that.
Look at the dates. It's a direct line.
April 23, 2019, about 4 months later. Ghislaine Maxwell is first mentioned in the case file. July 2, 2019, Epstein is indicted under seal.
7 months after the case opening.
And then July 6, 2019, Epstein is arrested at Teterboro Airport. August 10, he's dead. The investigation that was formally born on December 6, 2018, is what ultimately put him in that jail cell.
It was the starting gun. There's no other way to put it. It was the moment the clock officially started ticking on him.
So now we have to place them side by side. I'm literally doing it on the desk right now. Document A, FBI, opens a child sex trafficking case. Document B, Epstein's company, orders 330 gallons of sulfuric acid.
Both dated December 6, 2018.
As an auditor, you deal with probabilities. What are the chances of this being a random coincidence?
Look, anything is possible. But in the world of forensic accounting, we say coincidence is not a business model. It's a statistical anomaly of the highest order. Epstein owned that island for nearly 20 years. It's over 7,000 days. On the one single day the FBI formalizes its case against him, an order is placed for an industrial quantity of a substance that can destroy organic evidence.
So if we dismiss coincidence as being wildly improbable, what are we left with?
We are left with the tip-off hypothesis.
Meaning someone inside the system warned him.
It's the most logical inference from the data. Did someone at the SDNY or the FBI make a call to one of his lawyers? We don't have a record of that call. We don't have a smoking gun email.
Of course not.
But if you assume a tip-off occurred, This wire transfer looks less like a coincidence and more like an immediate calculated response.
And the nature of the response is what's so telling. The response wasn't to flee. It wasn't to issue a press release. The response was to procure a chemical agent.
A very specific chemical agent. Let's talk about what sulfuric acid actually does. H-Euro.
Right. We need to understand the tool that was being purchased.
On an industrial level, it's a dehydrating agent. It's used to make fertilizers, process, or refine oil. It's a workhorse. But on a biological level, it's catastrophic.
Explain the mechanism. How does it destroy organic tissue?
It's a twofold attack. First, it's a violent desiccant. It has an incredible affinity for water. When it touches skin, muscle, or any organic material, it chemically rips the hydrogen and oxygen atoms, the components of water, directly out of the molecules.
It literally dehydrates the tissue at a molecular level.
Yes, and this reaction is intensely exothermic. It generates extreme heat. So it's not just dissolving the material, it's chemically burning it at the same time. It reduces organic matter to a carbonized sludge.
And harder materials. What about bone?
Bone is mostly a mineral called hydroxyapatite. Sulfuric acid readily dissolves it. Given enough acid and enough time, it will break down the entire bone structure.
Which means it would also destroy any DNA evidence contained within.
It would render it completely unrecoverable. Hair, blood, skin cells, bone fragments. They would cease to exist in any analyzable form. If your goal is to permanently erase biological evidence from a location, sulfuric acid is one of the most effective and commercially available options.
Okay, but we have to be rigorous. We have to address the stated purpose, the RO defense.
Absolutely. We have to audit the alibi.
Reverse osmosis plants do exist on these islands. They're necessary for fresh water, and they do require acid cleaning to descale the membranes.
That is all factually correct. The membranes get fouled with minerals, mostly calcium carbonate from the seawater. An acid wash is standard procedure to clean them.
So on paper, the purchase is justifiable.
On paper. But a water treatment engineer would raise two immediate red flags. The first is the choice of acid.
Why?
The industry standard for descaling calcium carbonate is hydrochloric acid, HCl. It's effective, and its byproduct, calcium chloride, is highly soluble in water. It just washes away.
And sulfuric acid.
Sulfuric acid is risky in this application. When it reacts with the calcium in the seawater, it can create calcium sulfate.
What's that?
It's gypsum, plaster. If you get the concentration wrong, you can permanently clog your expensive RO membranes with rock. It's a choice an engineer would typically avoid unless they had a very specific, unusual scaling problem.
So it's a technically possible but professionally questionable choice.
That's a good way to put it. And then there's the second red flag, the quantity.
330 gallons.
It's just an enormous amount for a private residence, even a large one. The acid is heavily diluted for cleaning cycles. A 55-gallon drum could last a very long time for routine maintenance. Ordering 6 at once? That suggests a need for a massive volume of the chemical for something other than just membrane cleaning.
So the RO plant provides the perfect, plausible deniability.
It's the ideal cover. An auditor looks at the books, sees the RO plant exists, sees the invoice says RO maintenance, and moves on. The alibi is built into the island's infrastructure.
And the destination of this delivery is key. Little St. James.
The isolation is everything. Once those 6 drums land on that private dock, they vanish from all public oversight. There are no EPA spot checks, no workplace safety inspections. The chain of custody for 330 gallons of hazardous material ends the moment it touches private land.
And we have to remember what that land was as the primary crime scene. The FBI case that was opened on December 6 concerned abuses that largely took place on that island.
In the main house, in the guest villas, in that strange temple-like structure. If there was physical evidence to be found, DNA on a mattress, hair fibers in a carpet, blood stains on a floor, that's where it would be.
If you get a tip that the FBI is coming, your first thought is to sterilize the crime scene.
And we know from drone footage after his arrest in 2019 that there was a massive amount of construction and demolition happening on the island. But that was after the fact. This purchase, this potential cleanup, happened 7 months before his arrest. It suggests a proactive, not reactive strategy.
A strategy that was enabled, at least financially, by a major U.S. bank.
JPMorgan Chase. We have to come back to them. Their name is right there on the wire transfer document.
And we can't look at this transaction in a vacuum. We know that JPMorgan later paid a $290 million settlement to Epstein's victims.
We also know that a federal judge, in ruling on that case, stated that the bank had actual knowledge of Epstein's sex trafficking activities.
Actual knowledge. That's not just negligence. That's a finding of knowing complicity.
So, on December 6, 2018, an institution with actual knowledge that their client is a sex trafficker processes a payment for him to acquire a massive quantity of a substance that can destroy DNA evidence delivered to the island where the trafficking occurred.
All the compliance alarms that should exist inside a bank like that.
Yeah.
They should have been deafening. High-risk client, high-risk purchase, high-risk destination.
And yet the money moved, the wire cleared, JPMorgan played its role. They were the financial utility that allowed the lights to stay on and, in this case, the acid to be delivered.
Which brings me back to that blank line on the form. The missing signature. It feels more significant the more we talk about it.
Because it represents a deliberate gap in the record. It's a missing piece of evidence.
Procedurally, it shows a command structure where the boss's word is all that matters. The protocols are for other people.
Right. It suggests an order came down from the top. Make this happen today. I don't care about the paperwork. That's how things work in these kinds of closed organizations.
And it creates perfect deniability. We can't say for sure who gave the order. Was it Epstein himself? Was it a trusted manager? We don't have a name on that line.
We have a wire transfer requested by an LLC, routed through a bank for a chemical, delivered to an island. But the identity of the human being who initiated this specific, critically timed action that's been deliberately left off the page.
And this action took place in the context of an investigation that we know would eventually ensnare Ghislaine Maxwell.
Right. The FBI email, EFTA 001645551, has Epstein Maxwell in the subject line. She was a target from day one, even if her name doesn't appear in the case file until April 2019.
And when she was eventually tried and convicted, the prosecution relied on physical evidence. The email lists New York search photos, Palm Beach search photos.
Correct. They raided his other properties and found a trove of evidence. But the island was different. By the time they did a thorough search there, a lot of time had passed.
A 7-month window from December 2018 to his arrest in July 2019.
A 7-month window in which a potential suspect, who may have been tipped off about an impending federal case, was in possession of 330 gallons of sulfuric acid on a private, unmonitored island.
If evidence was destroyed during that period, it would have fundamentally altered the case prosecutors could bring, both against him and against Maxwell.
It could have limited the scope. The evidence presented at trial might have been only what was left after a potential sanitization effort. We're looking at a possible act of obstruction of justice that was laundered through the books as routine maintenance.
And it all comes back to that one day. If this purchase had been made on December 5th or December 7th, you could argue it away.
You could. But the fact that the two events, the case opening and the chemical order, share the same 24-hour window, that removes the shield of plausible deniability. In an investigation, you follow the timeline, and this timeline is screaming.
Okay, let's summarize what we know for a fact based only on these two documents.
Fact 1. The FBI formally opened its child sex trafficking case against Jeffrey Epstein on December 6, 2018. That is documented in ETEP 200016455.
Fact 2. On that same day, December 6, 2018, Epstein's entity, LSJE LLC, executed a wire transfer to purchase 330 gallons of sulfuric acid for delivery to Little St. James. That is documented in EFT 01223564.
Those are the fixed points. Now, what we don't know.
We do not know for certain if Epstein was tipped off. There is no documented proof of a leak.
And we do not know for certain what that acid was used for. We don't have a witness saying they saw it used for anything other than the RO plant. There are no consumption logs.
All we have is a convergence, a legal threat materializing on the exact same day as the acquisition of a tool that could be used to neutralize physical evidence.
It's the ultimate forensic question, coincidence or causation. The documents can't answer that. They can only pose the question.
The documents don't tell us whether Jeffrey Epstein knew the FBI had opened a case against him on December 6, 2018. They don't tell us what 330 gallons of sulfuric acid were used for on Little St. James Island. What they do tell us is that both things happened on the same day. And the authorization line on that wire transfer is still blank.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.